Today, I would like to talk to you about the merit-based green card. We'll talk about what this green card is, what the application process is, as well as the interview process. And if you stick around towards the end, I'll be sure to tell you my tips and any type of predictions that I have for the upcoming year. Hi, my name is Natalie Driver Womack, and I'm an immigration attorney, and I've practiced immigration law for 10 years. So this is a green card that is rooted in love and heart matters and family. So it's only fitting that our conversation is guided by the acronym of LOVE. So the L will be the legal requirements, the O will be the official filing, the V is the verification of the interview process, and then the E is the expectation. So let's get started with the L, the legal requirements. So the legal requirements would be that a U.S. citizen or lawful permanent resident can petition for their immigrant spouse so that he or she will be able to live, work, travel in and out of the U.S., as well as be able to file for citizenship in the future through the naturalization process. Now, the O aspect is the official paperwork filing. Here we have to determine, is the immigrant spouse in or outside of the country? If the immigrant spouse is in the country, then we would be processing and petitioning and submitting our documents to the United States Citizenship and Immigration Services. This is USCIS. So you can either petition and submit your filing via paper or online. The filing fees are different. So we're going to have a form, filing fee, and supplemental documents. So the first two forms that you would need to file to create what is called a concurrent filing is
an I-130,
which is a petition for alien relative, and that is $625 online and $675 in paper. And then there is the I-45, which is the adjustment of status, and this is $1,440, no matter whether or not you're filing it online or on paper. Now, the combination of these documents solidify the identity of the individuals petitioning as well as the marital status. So in order to solidify your identity, you're submitting any government-issued documentations and birth certificates for both the immigrant spouse and the petitioning spouse, which is a U.S. citizen or lawful permanent resident. Additionally, you will be providing your marriage certificate. Keep in mind that if you've had any previous marriages, you will also have to submit any documentation that shows that the previous marriages were dissolved. Now that we've created all the necessary requirements, we also have to submit paperwork that shows the joint union. So that would be documentations of joint financial accounts, a house and or a lease that's in both individuals' names. And if there are any kids from the marital union, you would submit the child's birth certificate. Now, there are additional documents that you should also file when filing the I-130 and the I-485. The additional document that I like to talk about first is the I-864. This is the affidavit of support. This document, you don't have a filing fee for. The purpose of this document is that the petitioning spouse, the U.S. citizen or the lawful permanent resident, is contracting with the government that states that he or she will be financially responsible for the immigrant spouse, that the immigrant spouse will not be what is deemed a public charge to the government, meaning that the government will not have to pay for this individual. And we'll talk about that later towards the end. Now, with this document, you'll have to also file your most recent tax returns. And when they're looking to assess how much an individual makes and what is an adequate amount of money, they always look at what is called the Federal Poverty Guidelines. So this will be a calibration of how many people are in the household and the amount that is brought in by the individual who is submitting the affidavit of support. If there are two individuals, you have to make at least
$21,150.
If there's three individuals in the house, you have to make
$26,650.
Now, another document that you should also file is an I-765, and this is an employment authorization document. So this is also known as your EAD. This is the application that asks the government and asks for permission so that the immigrant spouse can work in the U.S. This comes relatively quick after the filing, about 3 to 6 months after the filing.
And the I-131 for advanced parole should also be filed in the event that you need to travel in and out of the country.
Then the next thing is that you will now have all your documents filed, and then the next step will be that you will get a document that is called the I-797C. And this is an important document. This tells you your priority date. It tells you basically your line in your processing and that the government has received all your applications. I tell my clients to keep this on their person at all time. Now we talked about the processing for someone who's in country. Now we need to talk about the process for someone who is outside of the country. This is called consular processing.
Here you must first submit the I-130 and wait. Once you have approval, you will be notified in the mail, and then you will be able to submit your online application only for your DS-260.
So all documentations, a lot of the same documents that I'm talking about, the supplemental documents will be submitted, but the document will be a DS-260, and it would be submitted only online to the National Visa Center, the NVC. In filing the DS-260, you will also have a filing fee of $445. You will also have to file an affidavit of support. So now we've done the L, the legal requirements, the O, the official paperwork, and now we're moving on to V, the verification, the interview. So with an interview, whether or not you're in or outside of the country, you will be mailed notification of where to appear, the time, and the date. Please allow about 45 minutes for your travel time. You don't want to be late for that day, right? In addition to that fact, you're going into government buildings. Take as least amount of things as you have to. You're going to have to go through metal detectors. So you just want to make sure you're on time and you travel light. So now when I'm preparing both either my clients for an in-country or an out-of-country interview, what I make sure is that we review the paperwork, we make sure that we review what we submitted, and I tell them to discuss the history of your relationship. And when you go in, do not put on a show. Just be naturally who you are. When you put on a show and you're too lovey-dovey, you're too extra, that could be a potential red flag. So let's talk about the in-country interview. The in-country interview, you will go to your USCIS office, you would go through the metal detector, you will be put in a waiting room, the immigration officer will come out. The immigration officer will either come here, both of the spouses or one of the spouses. In that room can be your attorney, but the attorney does not answer questions. Only the individuals who are part of the marriage. Depending on your USCIS office, it'll determine how they conduct their interviews. A practitioner in your area will be able to help you and prepare you for that more efficiently. Now, if you're outside of the country, you'll be going to your consulate and your embassy, and only the immigrant spouse is able to be in that room to conduct the interview. So again, same preparation, I say, for both interviews, and just be yourself. Okay, now we go to the expectation. How long do I have to wait? What happens next? So now you'll have to wait 10 to 12 months for a denial or an approval. So if you get an approval, you could be deemed a lawful permanent resident, or you could be a conditional permanent resident. So if you're a lawful permanent resident, no further action is needed unless you want to eventually apply for naturalization to be a citizen. Now, if you are a conditional permanent resident, you will have to eventually file to have the condition removed. What triggers the lawful versus the conditional permanent resident? So it will be that if you married and you waited after 2 years to file, then you would be deemed a lawful permanent resident once approved. If it was before the 2 years, you're the conditional permanent resident. Now, with conditional permanent resident, you will have to file an I-751. This application you'll be submitting just to verify that the marriage that you entered into is valid and a bona fide marriage. Now, of course, life happens. Individuals, and I've had clients who've divorced. The only thing that we do is we continue to show that at the time of the marriage, we entered into a bona fide marriage. So I would show the connection, the joint information, the joint financial accounts that existed at the time of the marriage. Now, the good part, the tips. So now I think that this is a long process. I'm pretty sure that we've been discussing this for a while, right? So it is an important and a lengthy process, and I think it's important that you have a practitioner to truly help you navigate this, especially because my predictions for the upcoming year is that there's certain things that you're going to want to safeguard against. So for one, there's the public charge. We talked about whether or not the immigrant spouse would be a burden to the government. Throughout the last couple of years, we have not had to submit a document that is dealing with the public charge. But I believe that the public charge document will come back, and this is a document that you outline what your assets are, what your liabilities are, what your educational background is, what types of languages you speak, an additional document that you also have to fill out. So you have to be very mindful of what you're putting down and ensure that you're capturing the full individual that you're trying to present to the government. Okay? Then another aspect is if you are denied, that could potentially trigger immigration court because you could get an NTA. So an NTA is a notice to appear. And if the information that you submitted to the government, say you forgot to submit a document or you didn't think a document was important because you did not know, you could potentially be required to go to immigration court as opposed to simply refiling the application. So this is very important to make sure that you have a practitioner who's helping to make sure that you are filing all the appropriate documentation. Another important thing is to ensure that when you are submitting in country, when you're submitting that concurrent filing, be sure to submit your I-693, which is your medical exam. USCIS has a list of approved medical doctors that you can go to receive this medical report, and this should be submitted. Not submitting this could potentially result in a rejection. So again, we've gone through the whole love process, the legal requirements, the official paperwork filing, the verification, and then any type of expectation. So I believe we've covered it all, and I hope that this has been helpful, and that you just remember you've entered into a valid marriage. You just simply want the government to now make it so that it's easy for you to live